you.
Of course. All right. Hello, everybody. Thank you for joining us today on this Monday afternoon. Huge thank you to Britt Burner from Burner Prudenti Law, who's here to speak about guardianships and how to avoid them. Thank you for being here, Britt, and I'll give the mic right over to you.
Great, thank you. Thank you everyone for tuning in here today on behalf of Burner Prudenti Law, and we're being brought to you by the Shelter Island Public Library, who we love to team up with and bring you all sorts of educational topics regarding elder law and trusts and estates. And today we're going to be talking about guardianships and how to avoid them. This is the kind of topic that you don't know you need until you need it. And so we hope that there's some information that you can take from here and really some of the defenses to how to keep yourself out of a guardianship and out of the courts as you grow older and are dealing with your own planning. Our firm, Burner Prudenti Law, has offices in Manhattan and then throughout Suffolk County, all the way out to East Hampton. And we are happy to bring you this content today. So thank you for joining us. My two disclaimers are that none of this is meant to be legal advice. This is educational. So we're here to learn. And also, this is all based on New York state law. Each state has laws that are a little bit different when it comes to adult guardianship, or in some other states, they call it conservatorship. Here in New York, we call it guardianship. So this will only apply to New York residents. However, there's probably some connection or similarities from state to state. So what is guardianship? So guardianship is when the court is forced to get involved and appoint someone to represent the interests and make decisions on behalf of an adult individual. So we often think of guardianship in terms of children and who will be their guardian, who is their adult guardian. But here we're talking about adult guardianship. And usually it's because somebody had mental capacity, was able to handle things on their own, function perfectly fine in the world. And then there was some sort of event, or if not a sudden event, maybe a slowly diminishing capacity based on a dementia or other illness that created a lack of capacity that has created a situation where now this person is unable to handle their own affairs and they don't have any proper documents or situations in place to cover that need. And so I'm first going to talk about how you avoid guardianship, and then I'm going to talk about what a guardianship is going to look like. I want to start with how to avoid guardianship because hopefully if you're here listening today, you're not involved in a guardianship for a loved one, and hopefully you can then avoid one for yourself. We like to avoid guardianship because we like to avoid court involvement in our lives if we can help it, right? There are things you can do to make sure that you're cared for if you end up losing your capacity without involving the courts, which can just be difficult and frustrating and inefficient. Also very expensive, and we try to avoid that where we can. So the main way that we defend in advance and keep guardianship from coming into our life is by doing proper estate planning, right? If we have documents in place that are saying this person is empowered to make medical decisions for me, this person is empowered to make business or financial decisions for me, this is how things are to be spent, how my money is to be spent, how I want to live, to the extent that we write that out in legal documents in a clear manner, we can avoid this situation where the court has to appoint those individuals for us. So the first document I want to talk about is a power of attorney document. A power of attorney says who can be authorized to act on your behalf in terms of certain business or financial functions. So it could be something as simple as paying the rent or the mortgage or the real estate taxes, or it could be something much more complicated, such as paying paying for legal advice or paying, dealing with transferring assets around so that you can have a guardian, so that you can apply for Medicaid and become eligible. There's all different kinds of powers that we can authorize another person to do on our behalf. And this is what a power of attorney can do. We also often will put into the power of attorney document a nomination of guardian. So we can say, if a guardian should be necessary, then I want the person that I'm naming here to serve as that guardian. So if you're in a situation where maybe you have a power of attorney document that gives a certain number of powers, but there is a power not listed in that document that is needed, and you do not have the mental capacity to give that power out to someone, then the court can appoint a guardian to handle that power and use the person that you've nominated in your document. So that's really important. I also want to point out that not all power of attorneys are created equal, right? The power of attorney document is a document that is a state form that requires modification by an attorney or by someone who's aware of the type of powers that can be added in. And it's also something where if you have assets that another person is going to be given the power to handle, you want to have the right advice to understand what power you're giving away. So it's really important that you get good advice surrounding your power of attorney. You also want to keep informed about changes in the law. So a power of attorney is a form that's created by New York state law. But for example, in 2021, we ended up with a new power of attorney, right? The law changed. Now, that doesn't mean that prior powers of attorney aren't valid anymore. They certainly are still valid if they were valid when they were signed. But the changes in law might create a reason that it would make sense for you to update those documents. So you're going to hear me say this a lot, but plan early, plan often, right? You should be reviewing your documents every 3 to 5 years. Do they still make sense? The person that I've named to handle these financial affairs for me, can they still do it? Or do I have to make a switch up because life circumstances have changed either for me or for them, and they're no longer going to be an appropriate person to serve? If you have a power of attorney and that power of attorney agent has plenty of powers and they can handle what has to be handled for you, and they're doing a good job, then you won't end up with a guardian handling your financial affairs because you've already handled that. And you're going to hear me use the term least restrictive alternative because the courts don't want to get involved and overreach. So they want to use the least restrictive alternative. And that is actually in the Mental Hygiene Law, Article 81 Guardianship Statute for adult guardianships. What that means is if you have these things in place, then it is the least restrictive alternative to continue the use of those documents. It is not the least restrictive alternative for the court to overreach and take things over. Similar to power of attorney, we also want people to have healthcare proxies. This is going to say who makes medical decisions for you if you can't make them for yourself. Again, you want to name individuals who can act, who are willing to act. And then if someone tries to bring a guardianship to say that you don't have someone to make medical decisions for you, you have these documents in place as a defense. Now, you also want to think about what you're doing. So you have a power of attorney, you have a healthcare proxy. I had a client who named one person as their power of attorney and a different person as their healthcare proxy. That on its face is not a problem, should be totally fine. However, those two people happen to hate each other. So what happened was the healthcare agent was in charge of healthcare decisions and wanted to set up a certain level of care and a certain agency they wanted to bring in to provide home care. But the person with the purse, the power of attorney who would have to pay for all of that, didn't agree. And now we had a situation where these two people who couldn't work together have these jobs and it was incompatible. So you really want to think through what you're doing. You know, we call it estate planning because it is a full plan. These are not documents, right? They are documents, but we're not talking about what to sign in a vacuum, who to name as your healthcare proxy, in a vacuum, who to name as your power of attorney. We're talking about your estate plan, your plan for a time in your life where you cannot handle things on your own, and who you've empowered to do so, and what's that going to look like in practicality. You really want to play that through when you're making these decisions. Because what ends up happening when you have conflict like that is nothing happens, and you're more likely to fall prey to a guardianship because someone says, we're now at a point where nobody's doing anything and there is no one to handle these affairs because they can't make it work. And conflict leads to courts, leads to guardianship. So we want to avoid that where we can. Think about it in terms of your backup also, right? If you have a person named as power of attorney, a person named as healthcare proxy, and then the first instance, the healthcare agent can't act, who's the backup, and can that backup work with your power of attorney? So you want to, again, play through all the different scenarios to make sure that this is going to work out if that time should come where you do not have the capacity to handle your affairs on your own. So can they work together? Do you trust them? This is a given. If you do not trust the people you're naming, you shouldn't name them. Then you are better off with the court appointing someone, because you're talking about a time where you could be very vulnerable. You either have a total loss of capacity or maybe enough of a loss of capacity that you can't follow up on things on your own and check in. And you want to make sure that the individuals that you're naming are trustworthy and that you feel comfortable that they will only act in your best interest, and as you would if you could act for yourself. So then we start to talk about misfeasance versus malfeasance, right? There are the bad actors, misfeasance. So if you have somebody who, or I'm sorry, malfeasance. So if you have somebody who has a power of attorney, but they're taking advantage, they're maybe taking money for themselves or some other terrible thing, and they're not acting appropriately with the powers they've been given. And then you have those that just choose not to act, right? I have a healthcare proxy, I have a power of attorney, but maybe you didn't ask the people if they were willing to serve, or maybe they were willing to serve but became unwilling to serve, or maybe they themselves become incapacitated. So you want to think about who you're naming. Again, this is the importance of having backups, because if somebody is named as agent and they're not serving, you might as well not have signed the document. It doesn't get you anywhere. So misfeasance and malfeasance are often the things that put us in a guardianship, even when someone has these documents in place. Because obviously, if somebody's taking advantage of their responsibility, they're going to be held accountable, and we're going to have to find someone else to serve in that capacity. Or if someone's just not doing anything, you know, we see this unfortunately where the bills aren't being paid, they're mounting up, and then now we're in a situation where the individual has no one acting on their behalf, and they're losing the ability to gain certain services or pay their medical bills, etc. There could be a big problem, and that's where the court gets involved. Or bad documents, right? So you might have a document that's not valid, or you didn't follow the statute when you signed it. It makes me very nervous when people just find a power of attorney that they Google on the internet, print it out and sign it. It might not be in line with the New York State requirements. So you want to make sure that if you are doing it on your own without an attorney, that you're getting the power of attorney document from a valuable and trustworthy source. You also want to make sure that you're getting advice surrounding the document. Again, as I mentioned before, because if you don't know what you don't know, then you can't figure out what powers you should maybe be adding into the document that aren't in the standard state form. You want to understand exactly what powers you're conferring on another person, what are the pros and cons, and then make a decision about how you want to proceed. So bad documents can also put us in court in a guardianship. And I said it before, I'll say it again, plan early, plan often. Sign your documents and then review them and make changes as necessary. People move, they get married, they get divorced, they have babies, they have grandbabies, they lose their jobs, they retire, they things change over time. So a power of attorney or a healthcare proxy that you signed 5 or 10 years ago might not make sense anymore. Those might not be the right individuals. And you want to make sure that you're naming people who are really going to step up and take on this responsibility. So now what happens, right? We're in a situation where maybe you never signed these documents and you have a loss of capacity, or you have signed these documents and there's a problem either with the people serving, or they're choosing not to act, or they're incapable of acting. Then what do? Well, that's when we end up in a guardianship proceeding. Guardianship, again, is in this context, is talking about adult guardianship. This is about somebody who had capacity, who was operating in the world, and then because of either an illness or an incident, has a loss of mental capacity. Now, let's start right at the top of that, right? What does that mean to have a loss of mental capacity? It means that there are things that you should be doing in your day-to-day life that you cannot do for yourself. It does not have to mean a total loss of capacity, but also just being diagnosed with something like dementia or Alzheimer's or TBI, traumatic brain injury, isn't enough, right? You could be diagnosed with dementia, but still have the ability to handle your affairs on your own and act on your own behalf. So just having a diagnosis is not going to do it. What we're talking about is a real loss of ability to handle your affairs. Maybe you don't have the cognitive functioning necessary to get the mail, open up the envelopes, go through them, determine what should be paid, write out the checks, then go mail the checks, right? The steps necessary, that is hard for you to process on your own, and you don't have someone in place who can handle that for you. Or perhaps you don't have the ability to come up with a proper discharge plan, right? We see this when people are in a hospital or a nursing home and it's time to go home, but the facility is saying that you require care at home, but you don't have the functioning necessary to pull together that plan, to get the home care in place, to get the bills paid for the agency, etc. So when someone does not have the ability to handle those things, that shows a diminished capacity that might require a guardianship. Again, if there's nothing else legally in place, like a power of attorney or a healthcare proxy, to take that over. I'm going to talk about different terms. So we use the term AIP, that's the alleged incapacitated person. So if I am bringing a guardianship saying that another person is incapable of handling their affairs, I am the petitioner, because I'm petitioning the court to appoint a guardian for an alleged incapacitated person. Once they have been deemed incapacitated by the court, they are what we call an IP, an incapacitated person. Or in certain circumstances, somebody knows that they can't handle their own affairs. They have the mental capacity necessary to consent to a guardianship, maybe just not to handle all of those jobs for themselves, but they can consent to the guardianship. And when a guardianship is on consent, because a person is not deemed incapacitated, that's what we call a PING, a person in need of a guardian. I have had clients who have gotten into their 80s and they live alone and they don't have any family members that are able to assist them. They don't have any close friends that are able to assist them. And so they've actually petitioned the court and requested that a guardian be appointed to act on their behalf so that they have court oversight and they are what is called a PIG, a person in need of a guardian. So what's the process? So the process is the petitioner brings a petition to the court. So you put a petition together and send it into the court and say to the court, I believe this person can't handle these certain things. These are their functional limitations. These are some examples of what they can't handle and where there's problems. And I'm asking you to appoint a guardian. And I'm asking you, maybe I have a specific person in mind. Maybe I want to be guardian. Maybe I have a sibling that I want to serve as guardian. Or maybe I'm asking the court to appoint someone who's independent, perhaps a lawyer off the court's list or something like that. And also, what powers am I asking for? Because remember, I'm going to use the word again, least restrictive alternative. So if a guardianship is the least restrictive alternative, the court does not want to give powers that aren't necessary. So you want to make sure that the powers that are given are strictly tailored to the situation that the individual is in. You want to say, is there's a power of attorney, then why is that not good enough? What's wrong with that power of attorney? Is the person not acting right, or does it have specific missing powers? Is there a healthcare proxy? What is the reason that this guardianship is necessary and that there's no other way that we can accomplish what we're trying to accomplish here? This can be difficult with mental health patients often. Or it can also be difficult with, some people say to me, I want to bring a guardianship because I want to force somebody into mental health treatment. Well, that is treatment over objection. That is a different part of the statute, and that's something different. So when I sit with someone to talk about whether or not we should bring a guardianship, I say, what are you trying to do? What is your goal here? Because we're involving the court. It has costs associated with it. And is this what we really need? Because I don't want to set people up for failure, right? We want to set people up to say, this is what you need, and this is a realistic goal. If somebody says, I want to be able to force my loved one to take medications that they don't want to take, well, that's a whole other issue. And that's just because you're guardian doesn't mean you can force somebody to take medications that they don't want to take. And so we really like to look at what it is that you're trying to accomplish. You submit that petition to the court with what's called an order to show cause, which is an order that the judge will then sign if the judge thinks you've made your case well enough in that petition, which will set a hearing date for 28 days out, and usually appoint a court evaluator, which is an independent person. It's the eyes and ears of the court, which is meant to do an investigation so that at that hearing 28 days later, that's part of the testimony that's put on the record. And there's usually a written report as well. This is the court evaluator. They went out to the individual's house. They talked to the family members. They talked to anyone involved. They did an investigation maybe of the finances, whatever's necessary. And they're recommending to the court whether or not a guardian should be appointed, who is an appropriate person to name as guardian, and what those powers should be. Sometimes the order to show cause will also appoint a lawyer to represent the person that we're alleging to be incapacitated, that AIP. So if it looks as if the person is not going to consent, or they're going to flat out argue and say they don't need a guardian, or if temporary powers in the interim in that 28 days are being requested, then they'll often appoint a lawyer for that individual. And then notice of the guardianship is given to certain family members, your spouse, your children, if you have siblings. So if the guardianship is for an individual who has 4 adult siblings, then we will also give notice to those adult siblings. We also give notice to someone who is living with the individual, or if that person is in a facility, we let the administrator of the facility know that the guardianship is coming and that it has been filed and the order to show cause was signed. So then the question becomes, what is the court going to do now, right? So this guardianship has been brought, the court evaluator is doing their investigation, and now we're at the hearing phase. So again, it depends what situation we're in. In a simple guardianship where nobody's arguing it, but let's say the person is in a vegetative state, so they're unable to speak or express their wishes in any way. They didn't sign any documents saying who it would be. There's a family member who has brought the petition and is willing to step up, and everybody's in agreement. A hearing is still required. It still has to go on the record with the court that this person is incapacitated and why they're incapacitated. And then the court evaluator will say what the results of their report are, and the court can appoint a guardian. That's a very simple situation. Or you can go and create a much more complicated situation where maybe it's on the fence whether or not this person is incapacitated, and proof has to be put on the record to prove that the person's incapacitated. Or it's clear that they're incapacitated, but it's not clear who should be the guardian, right? There's warring parties, there's different individuals that want to serve with, and they have their own interests. The court has to look into that, and all of that evidence has to be put on. So depending on the circumstance, depends on what this hearing is going to look like. It depends how long it was going to be. You do have a right to a jury trial and a guardianship. However, in many circumstances, it's usually the judge that actually makes the decision themselves from the bench, and they will determine who is the appropriate guardian. So I should say, if the person's incapacitated, if a guardian's needed, who the appropriate guardian would be, and what the powers would be that the guardian would have. Again, it's the least restrictive alternative, so we are not looking to give powers that aren't needed. In some circumstances, there is a power of attorney in a healthcare proxy, but there's a missing power, right? The power to place somebody in a facility might be missing, and so we might be asking the court to do that. Or maybe there's not appropriate real estate powers in the document, and the property can't be handled or it can't be sold. It depends on what powers have been given, and the court can always extend those powers. The important thing when determining if somebody has the capacity is, do they have functional limitations that impair their ability to provide for the personal needs and property management? So are there failures in their ability to act on their own behalf? And do they understand these failures, right? Do they understand that they can't do these things? Because sometimes we have individuals who cannot act on their own behalf, yet they don't believe that. They don't think that's true. They think they're just fine. And so they're not putting other things into place because they don't even think anything's wrong. So do they understand consequences of this inability to handle certain things on their own, if they even recognize that there's this inability? And are they likely to suffer harm because of this? If they're likely to suffer harm, the court is going to be more likely to appoint a guardian to step in so that harm is not brought to this person based on their incapacity. And is a guardian going to prevent this harm? And is that going to be helpful? Again, exactly which powers are given is based on the least restrictive alternative. So the idea is we give the guardian the powers they need and nothing more. And then also the duration of the appointment. So a guardian might be appointed for 6 months, for a year. It might be for a certain amount of time, and then a redetermination if the person has gotten better. And then usually it's for an infinite duration. But even if it's for an infinite duration, you can still go back to the court and state that circumstances have changed and for the guardianship to be terminated. So for example, if you have somebody who has a guardian and then now down the line, they no longer have a guardian because they are not in need of that level of care anymore. Maybe they've were in a vegetative state and have come out of that. They can handle their own affairs now. You can petition the court for a termination of that guardianship. And then who will be the guardian, right? So again, did the petitioner of the proceeding, do they want to serve as guardian? Is it a family member? Does the court use what's called the Part 36 list? It's where the court appoints individuals who serve as guardians as part of their profession, or is it by nomination, a family member who nominates someone or the court who nominates someone? So it's not off that court's list. Once a guardian is appointed, they have annual accounting requirements. So there's the expense and the time of the actual hearing, but then ongoing, there are requirements. So as power of attorney, we very often don't have to tell the court or report or account to anyone about how much the is being done, what's money is being spent, a day-to-day accounting. However, with the court, you do have to once a year do an accounting. So that's an ongoing requirement for the individual serving as guardian, and that's oversight of the guardian. There can be post-judgment motions. So let's say somebody's appointed as guardian, but then they have to come back to the court and ask for the ability to sell the property that the person owned, or to move the person to an assisted living or to a different home, or perhaps they're asking for other additional powers that they weren't given in the initial guardianship. That can always be done. It's not that it's done forever once you have that initial hearing. And then those expansion of powers, those additional powers can always be granted, again, for a limited period of time or for longer. So as you can see, a guardianship is very complicated because we're in the court, the judge is making a decision, there's an independent investigation. It can be very intrusive into somebody's life. And so if you can avoid a guardianship and you can avoid not being in control of what happens in the future because you have identified who will act on your behalf and what powers you're giving them, you will be in a much better situation than if you have to involve the courts, again, with the time and the expense that requires. And so proper estate planning is very important to make sure that you keep yourself out of that guardianship court and keep your affairs private. Well, thank you so much for tuning in. I'm going to stay around and answer any questions. There is a chat on your Zoom, so you can feel free to click on that, and we would be happy to answer any questions. Again, my name is Britt Burner from Burner Prudenti Law, and I'm happy to be here on behalf of the Shelter Island Public Library to bring you this educational seminar.